Welcome to Chapter 14, Bringing the Accused Before Court. The learning outcomes, or big takeaways in this chapter, are listed in this slide. There are 5. After going through this chapter, you should be able to explain the process of laying a charge under the criminal code, and explain the process where information is laid first, and the process where information is laid second. Also, you should be able to demonstrate an understanding of the powers of arrest of a police officer, and finally, demonstrate the understanding of a private citizen's power of arrest. The big takeaway on is how do we get the accused before court? So a criminal action or something illegal has happened, and how do we get the person who is the accused before a judge to be determined if they're guilty or not guilty? Sometimes the person who has allegedly committed the offense gets arrested, and other times they don't. So remember, or the big key takeaway, just because someone's been charged with an offense does not mean they've been arrested. Actually being arrested is more the exception than the norm to the rule, and I'll explain that soon. So the first process, laying the information of Form 2 first, and then obtaining a summons or an arrest warrant. What we're really talking about when we're laying in information is going to the court and someone telling a judge, a master, or a justice of the peace that an alleged violation of the criminal code has happened, and that we need to somehow bring the accused before court for them to answer for what they have done. And so the information, it's a document that is done by someone who is an informant. And if you were in class, this is a little bit of a review, there is an example of an information in the appendix in the back of your textbook. It is, let's just look for it there. It is Precedent Form 2, 6, and 7. And again, let's just find your page there. I should have a page for this, I apologize. So it is Form 2 on page 408 of your textbook. So this is an information. So the ones in your textbook is quite a blank one. And this would normally be done by a police officer, what the offense is there. So that would be that. So the police officer would prepare this, go before a justice of the peace, explain it, and the justice of the peace would enter or approve the information. So if satisfied, the justice endorses it and issues a summons or issues a warrant. So a summons is basically another document that's prepared in which the accused is told to appear in court at a certain date and time. If any of you have received any sort of traffic ticket, you'll know that if you don't pay what the fine is, you're supposed to appear in court at a date and time. That's a summons. Or issue a warrant. So that basically tells the police officer, come get that person, go get them, and bring them before me. So that's your first system there. And then the warrants usually only executed in the province of issue. So if a police officer went before a justice of the peace in Alberta, they could only arrest the accused in Alberta, and only the police in Alberta would know about it. But there are criminal code provisions to allow for Canada-wide warrants. But remember, the rule is not to have them appear before, not to arrest them. It's usually a summons unless it's in the public interest. And public interest, we're talking about our safety, evidence being destroyed, or we think the accused may leave the country or something. The accused is generally if there are a warrant held in custody prior to the first court appearance. Or a bench warrant may be issued if the accused does not appear in court following a summons. So if it says, give this to the accused, they have to show up. They don't show up, the judge says, well, now I want to see them. Go arrest them. So that is your first to actually formally charge the accused, and then either tell the accused to show up or get them arrested and appear right away. And the second process was not possible to lay any information. There are two other options. So it's either arrest without a warrant or an appearance notice. So a summons is issued by a judge or justice of the peace. An appearance notice is issued by the police officer. Again, go take a look at your traffic ticket if you got one. So let's take a look at the arrest without a warrant process. So section 495(1) of the Criminal Code permits an officer to arrest without a warrant if the officer has reasonable grounds to believe the person has committed or is about to commit an indictable offense. Remember, your indictable offenses are your more serious ones. The officer finds the person committing any offense, so they're caught in the act or caught red-handed, however you want to think of that. Or the officer has reasonable grounds to believe that there is an executable warrant out for the arrest of the person. So it might mean they're not doing anything at the moment, but there might be a warrant for them. And certain less serious offenses, as listed in section 495(2), impose a duty not to arrest unless necessary. So think of the time and expense that incurred when someone's arrested. Also remember our charter rights, that we are free in a society and that we shouldn't be unreasonably detained. So there's got to be a reason for it. So you have to be found doing something, or so a little bit more on officer's duty not to arrest. They're not to arrest unless it's in the public interest. Think our safety is at risk, or with the police officer doesn't think they'll appear in court. Public interest, also to establish a person's identity, to secure or preserve evidence, to prevent continuation or repetition of the offense, or prevent commission of another offense. So there's always got to be that balance between public interest and the accused's right not to be detained unless there's a reason. So let's take a look at when they're not arrested and what is an appearance notice or your Form 9. So you do have your Form 9, again in the appendix of Volume 2 or Edition 2 of your textbook. That is on page number 417. So an appearance notice issued by a peace officer to a person not yet charged with an offense. Because remember, the charging happens by the justice of the peace. So that is what's the Form 9 is there. And you can take a look. There's a little bit more detailed wording on that. So that's page 417 of your textbook. So section 496 permits an officer to issue an appearance notice if the grounds do not exist to arrest without a warrant. So think back to the previous slide, public interest, establishing the identity, preserving evidence to prevent them from doing it again, stuff like that. It compels the accused to attend in court on a specified day and time to answer the charge. Note, following arrest without a warrant or an appearance notice, the officer must swear in information as soon as practically possible before a justice. So following arrest without a warrant or an appearance notice, so the information always has to follow. Again, that's that Form 6 in your textbook. Justice may cancel an appearance notice if he or she is not satisfied reasonable grounds exist. So the police officer can do an appearance notice, but the justice of the peace or the judge has to approve of it and can say, no, you're not going forward. I don't want to see them. So is other aspects of power to arrest, aka a citizen's arrest. I'm not sure this is something I truly would ever want to try, but the criminal code does allow its provisions. So take a look at section 494(1) of your code. So when can you and I, assuming that you are not a police officer, because I know I'm not, offender is found committing the offense or has just completed it, applies to all criminal indictable offenses, but not to summary conviction offenses. Now, think about this one. Before this course, did you know the difference between a summary conviction and an indictable offense? Bet you didn't. No, I bet you most people don't. And if you're going to do this, if you're going to do a citizen's arrest, if you're going to pretend you're a police officer, you must use reasonable force and must turn accused over to police forthwith. So ASAP, right away. Supreme Court of Canada has not addressed application of charter rights to these situations. I'm sure there's probably one coming sooner than later. So when you're using reasonable force, the criteria to determine that is likely to cause death or grievous bodily harm. So you can do a citizen's arrest, just don't kill them or hurt them a lot, I guess is what you're supposed to take away from that. So that's all I have for chapter 14. Again, if you have any questions, we can definitely go over that during our virtual class time.